We have to get to a break, but very quickly, let's bring in our guest that's standing by, National Trial Attorney Michael Jaafar, to help us kind of understand the prosecution's plan here. Michael, the cross-examination has had a lot of specific questions, and then the prosecutor will wait a few minutes and then come back to similar questions. What do you think the goal here is, and what may we expect towards the end of this cross?
I think at the beginning of this case, it seemed as though her story was inconsistent, but wow, has she really created consistency in what she said before the charges and after the charges. So I think the prosecutor is trying to pick holes and get some inconsistencies to break down her credibility. Because if the jury believes she's not credible, they're gonna rule for a conviction. So I think the prosecutor's trying. He's talking very fast. This is a very sharp prosecutor with a great grasp of the verbal tone of a courtroom, and I'm riveted watching him go back and forth. But it seems like he met as a match.
All right, Michael, well, that's an interesting observation. Thank you for your insights. We are going to get in a quick break. You are watching Court TV, your front row seat to justice. We'll be back.
All right, and we have our legal analyst standing by, who I can't wait to hear what he has to say about the end of this cross-examination. Let's go back to the cross. That redirect is really small. Michael Jaafar, National Trial Attorney, standing by. What did you think? I know you initially said you were riveted. By the end of it, did you still feel like this was a full, effective cross-examination?
No, my opinion wasn't that the cross-examination is effective. My examination, and I was just telling a colleague of mine, what that prosecutor did was hard. It was very, very hard. We were seeing the finished product, right? What I thought was that he had a good grasp of courtroom lingo, right? But he was trying to poke holes. He couldn't do it because he met his match. This defendant is very effective. She was very prepared, and she doesn't get rattled. She didn't get rattled at all. But what I want the viewers to know is what that prosecutor did was very hard. He was in their bedroom. He was in their living room. He was talking about the man cave. He had such a deep grasp of the facts that this prosecutor in the future, if he has a defendant that has inconsistencies, this is probably the worst prosecutor of that person's. It'll be a nightmare. This prosecutor was very prepared. He had a full grasp. He was able to respond to anything she said, and he was trying to poke holes. I don't think he was effective because this witness was so prepared, and it seems like she was just telling the truth. She had the truth on her. She had the truth on her side. Had her husband not died of blunt force trauma, I don't think these charges would have been brought. These prosecutors' hands were tied. They had to bring the charges. He died at his home. She was the last person to see him. He was basically run over by something. But other than that, she stopped this prosecutor. She made it ineffective because of her presentation. But what he did is very, very, very hard. Weeks of preparation with a big caseload on his desk. This prosecutor, I don't envy. I don't envy what he had to do here.
That's good to bring out.
Yeah, it is. And Mark Phillips, he died in this case, so it's a very sad case, Michael. When we talk about the charges, second-degree reckless homicide, the elements, that's, of course, what's going to be important. And the state has to prove that she caused the death of Mark and that she caused the death by criminally reckless conduct. Do you think the state has met that burden?
It's close. It's close. It's a great question. I was hoping you wouldn't ask me that question because I don't have an answer to it, because it's such a great question. Did they do it? Because she was the last person to see him. And they had a heated argument, and she clearly loved him. And, you know, they were almost like in the middle of nowhere. Like, what's the likelihood that a mailman ran him over at midnight on a Friday night? It's not likely. What's the likelihood that a friend, and it's snowy outside, everyone's driving slow, everybody's careful, whereas there were footsteps, footsteps coming in and out towards the car. She was there. She slept in the parking lot of a hotel, came home at 2 in the morning, didn't see him. I think they did, because the elements don't say that she premeditatedly murdered her husband. I think they did. It's close. It's so close. But I think I'm leaning towards saying they have met that burden, because that burden is recklessness. It's not intentional.
Right, exactly.
Very true. And it sounds like, Michael, that you're saying that it was a good thing that she took the stand, which is rare sometimes to say that for defendants. We do need to squeeze in a break.
Was across just is so sweet, and I loved what she had to say. My mom was not hurting me. So when they were hearing this yesterday, the judge, the jury, with their opinion and what they came down with the verdict, and just the sense of emotion overwhelming, and how she just said, my mom was not hurting me. So it's a vindication.
That's the message they wanted to get out to everyone. My mom was not this person. The hospital said that she was.
Exactly. Let's bring in National Trial Attorney Michael Jaafar to talk about this. Michael, obviously, Johns Hopkins says they are going to appeal, something you have to kind of assess if you're going to appeal a case like this. There's interest. I looked up what the interest is in Florida on judgments. It's around 7%. So they have to take that into calculation, but obviously they probably should appeal.
Yeah, I've been the Darth Vader analyzing this case for a long time now and telling people that, you know, I don't believe that the jury should render a verdict anywhere close to $200 million. What I've seen in my career is almost every one of these large landmark settlement verdicts against a municipality, a large corporation, or a nonprofit almost always get reversed the amount on appeal, right? People don't understand these hospitals are not profit businesses. They're like nonprofit entities. And so I don't see how this is going to survive appeal in terms of the amount. I really, truly am confident in saying, well, we'll see this in about a year or 2 years, that this will be brought back into the single-digit millions of dollars. You know, because they cause emotional distress. But an appellate court is going to come back and say there was no affirmative act by them to murder the mother, and the emotional distress is tied to the loss of consortium of your mother. So this is going to come back on appeal. First of all, this hospital doesn't have $250 million. These are nonprofit organizations. Hospitals are not profit businesses. And so people don't understand, there isn't $250 million. There isn't even $50 million in that hospital's coffers to write a check and pay this off. So the hospital will either shut down, it's a nonprofit organization with government funding, or it'll come back on appeal. That's my analysis of it.
I will say the punitive case, they claimed, the plaintiffs did, that they have $1 billion or $500 million in reserves for those punitive damages. But Michael Jaafar, just real quick, we only have about 20 seconds. This is a $260 million case. You handle cases like civil cases. I know you said that this kind of case would not have been one you would want to take, but do you think it is historic in the fact that it could be the largest in the country?
Oh, absolutely, it's historic, yeah. And if for no other reason, everybody now knows what CRPS is. I've learned about it during this case. So the case is definitely historic. The amount is historic. Everything is definitely historic. I agree.
Thanks so much, Michael. So good to have you on.